Welcome to Law and Society. Today I'm going to do a review of the DC Circuit Court of Appeals ruling that Donald Trump does not have immunity from criminal prosecution. It is a welcome day for justice, albeit about a month later. So I was dissatisfied by how long they were taking, but now am quite satisfied by their ruling and the thoroughness of the ruling. So I will jump right in. And if you're new to my channel, please like and subscribe, and let's go. So I'm going to read you from the beginning of the opinion and excerpts, as I always have, and explain parts of it as I go along. So the court starts out with Donald Trump was sworn into office at noon on January 20th, 2017, and served until his term expired at noon on January 20th, 2021. At that moment, President Trump became former President Trump, and his successor, Joseph R. Biden, became president and began his own 4-year term. This is important in the timeline. As we go along, you will hear why. For the purpose of this criminal case, former President Trump has become Citizen Trump with all of the defenses of any other criminal defendant. But any executive immunity that may have protected him while he served as president no longer protects him against this prosecution. So the court is slowly going and giving us an overview of what their ruling is going to be. Then the court goes through the background of what happened, and amidst that description, there is this excerpt. On January 11, 2021, 9 days before President-elect Biden's inauguration, the House of Representatives adopted an impeachment resolution charging then President Trump with incitement of insurrection. This point will be important towards the end when we talk about the double jeopardy issue. Importantly, by the time the United States Senate conducted the trial on articles of impeachment, he had become former President Trump. At the close of the trial on February 13, 2021, 57 senators voted to convict him and 43 voted to acquit him. Because 2/3 of the Senate did not vote for conviction, he was acquitted on the article of impeachment. This part will also come into focus later on in the reading and the review when we're talking about his impeachment proceeding and the double jeopardy principles. Then going to the procedural part of the indictment that is underlying this particular appeal. A Washington, D.C. grand jury returned the instant 4-count indictment against former President Trump on August 1st, 2023. And on August 28th, 2023, the district court set a trial date of March 4th. Former President Trump filed 4 motions to dismiss the indictment, relying on presidential immunity, constitutional provisions, including the impeachment judgment clause, and principles stemming from the double jeopardy clause, statutory grounds, and allegations of selective and vindictive prosecution. On December 1st, 2023, the district court issued a written opinion denying the 2 motions that are based on presidential immunity and the 2 constitutional provisions. In relevant part, the district court rejected Trump's claim of executive immunity from criminal prosecution, holding that a former president enjoys no special conditions on their federal criminal liability. It concluded that the Constitution's text, structure, and history do not support the existence of such an immunity, and that it would betray the public interest to grant a former president a categorical exemptions of criminal liability for allegedly attempting to usurp the reins of government. It also held that neither traditional double jeopardy principles nor the impeachment judgment clause provide that a prosecution following impeachment acquittal violates double jeopardy. Then, former President Trump filed an interlocutory appeal of the district court's presidential immunity and double jeopardy holdings. The appellate court then goes into a discussion of uh, jurisdiction, of how they have jurisdiction. I will not talk much about this because it's very technical. It doesn't go into the substance and the merits of the case. So, just an interesting point here I want to make is the court says that under 28 USC 1291, which grants us jurisdiction over final decisions of district courts, we ordinarily do not have jurisdiction to hear a defendant's appeal in a criminal case prior to conviction and sentencing. So it's important enough that the court said that, we ordinarily do not have jurisdiction to hear a defendant's appeal in a criminal case before conviction and sentencing. The collateral order doctrine, however, treats as final and thus allows us to exercise appellate jurisdiction over a small class of interlocutory decisions that conclusively determine the disputed question, resolve an important issue completely separate from the merits of the action, and are effectively unreviewable on appeal from a final judgment. So this particular case, talking about immunity, because if there were immunity, then Donald Trump would not have to go through the case at all, and so the going through the case would become moot. And if the case went through and then the appellate court judged on the issue of governmental immunity, it will be a waste of judicial time to go through the trial process. And so the court explains here why they are granting appellate jurisdiction. So then the court points out, and the court will talk about it later on, the double jeopardy principle that Donald Trump relies on is a negative implication drawn from the impeachment judgment clause. This is a part that the court, I believe Judge Childs, asked about and pointed out more than once during the oral arguments, that Donald Trump is using a negative implication of the impeachment judgment clause, not what the judgment clause says. In fact, the judgment clause is completely, as we will see, doesn't say anything to the effect of what Donald Trump would have impeachment judgment clause say. The Supreme Court held that an order is effectively unreviewable on appeal only where the order at issue involves an asserted right, the legal and practical value of which would be destroyed if it was not vindicated before trial. So, I just want to explain to you the jurisdictional, this interlocutory appeal, this mid-trial appeal. First of all, it's generally in civil cases you see interlocutory appeal, and the court points that out. And the court also says that under the collateral order doctrine, we do have jurisdiction. Excuse me. Now going on to the substance. Executive immunity. For all immunity doctrines, the burden is on the official claiming immunity to demonstrate his entitlement. So at the very offset, we see the burden of proof. It is Donald Trump's burden of proof that he has executive immunity. And we will see in this case that he doesn't prove it. The question of whether a former president enjoys absolute immunity from federal criminal liability is one of first impression. So, this is the case of first impression. We've never had this case before. This is something that the court is handling as the first case of its kind. Because remember, Nixon was pardoned. And so there was no prosecution. And we'll also see that there was a deal made by Clinton to avoid criminal prosecution as well. The Supreme Court has consistently held that even a sitting president is not immune from responding to criminal subpoenas issued by state and federal prosecutors. In the civil context, the Supreme Court has explained that a former president is absolutely immune from civil liability for his official acts defined to include any conduct falling within the outer perimeter of his official responsibility. Both sitting and former presidents remain civilly liable for private conduct. When considering the issue of presidential immunity, the Supreme Court has been careful to note that its holdings on civil liability do not carry over to criminal prosecutions, which is the case here. Former President Trump's claimed immunity would have us extend the framework of presidential civil immunity to criminal cases and decide for the first time that a former president is categorically immune from federal criminal prosecution for any act conceivably within the outer perimeter of his executive responsibility. He advances three grounds for establishing this expansive immunity for former presidents. One, Article 3 lacks power to review the president's official acts under the separation of power doctrine. Number two, functional policy considerations rooted in the separation of powers require immunity to avoid intruding on executive branch functions. And number three, the impeachment judgment clause does not permit the criminal prosecution of a former president in the absence of the Congress impeaching and convicting him. Our analysis is guided by the Constitution, federal statutes, and history, as well as concerns of public policy. Relying on these sources, we reject all three potential bases for immunity, both as a categorical defense to federal criminal prosecutions of former presidents and as applied to this case in particular. So it is a broad ruling here. It is saying that we are discussing specifically this case, but we're also talking broadly about the presidential immunity of former presidents. So you can see how thorough the court is being by categorically dismantling Donald Trump's argument and setting the stage for explaining why. I take a quick drink of water. So thank you so much for being here. Just to let you know, if you're new to my channel, please like and subscribe. What I'm doing now is going through the DC Circuit Court of Appeals opinion that stated and ruled that Donald Trump does not have absolute immunity from criminal liability. Donald Trump has a lot of choices at this point. He may appeal, then the Supreme Court may either reject the appeal, accept the appeal, and put a stay on the lower court's trial proceedings as it has, as the appellate court did, or take the review and let the case go forward. And you know, I believe the best option would be to let the case go forward and let the DC Circuit's ruling stand on governmental immunity and deal with this altogether when the final ruling of the underlying case happens. That would be the best way to go. So going back to the separation of powers doctrine. So now the court breaks it down. The President of the United States occupies a unique position of constitutional scheme. in the constitutional scheme. Under the separation of powers established in the Constitution, the president is vested with executive power, which entails the duty to take care that the laws be faithfully executed, and supervisory and policy responsibilities of utmost discretion and sensitivity. The president's constitutional role exists alongside Congress's duty to make the laws and the judiciary's duty to say what the law is. It is settled law that the separation of powers doctrine does not bar every exercise of jurisdiction over the President of the United States. Nevertheless, former President Trump argues that the constitutional structure of separated powers means that neither the federal nor a state prosecutor nor a state or federal court may sit in judgment over a president's official acts, which are vested in the presidency alone. Former President Trump misreads Marbury versus Madison and its progeny. Properly understood, the separation of powers doctrine may immunize lawful discretionary acts, but does not bar the federal criminal prosecution of a former president for every official act. Marbury distinguished between two kinds of official acts, discretionary and ministerial. When the president or his appointed officers exercise discretionary authority, the subjects are political and the decision of the executive is conclusive. Their discretionary acts, therefore, can never be examinable by the courts. But Chief Justice Marshall continued, when the legislature proceeds to impose on that officer other duties, when he is directed peremptorily to perform certain acts, when the acts of individuals are dependent on the performance of those acts, he is so far the officer of the law, is amenable to the laws for his conduct, and cannot, at his discretion, sport away the vested rights of others. Under these circumstances, an executive officer acts as a ministerial officer, compellable to do his duty, and if he refuses, is liable to indictment. Based on these principles, Chief Justice Marshall concluded that although discretionary acts are only politically examinable, the judiciary has the power to hear cases where a specific duty is assigned by law. Marbury thus makes clear that Article 3 courts may review certain kinds of official acts, including those that are legal in nature. When the president takes measures incompatible with the expressed or implied will of Congress, his power is at its lowest ebb. Now, taking a break from the reading, when I was in law school, we were taught in constitutional law that a president's executive authority is at its lowest when it goes against the laws of Congress and the courts side with Congress. So that's where the presidential power is nullified in the checks and balances and the separation of powers doctrine. On the other hand, if the president has the backing of the law, if the law favors the president and the courts say that the law backs the president, then the presidential authority is at its zenith. It's the highest that it can be. So here, the court makes it a point to say that when the president's conduct is incompatible with expressed or implied will of Congress, his power is at its lowest ebb. Based on precedent, Youngstown and Marbury, the Supreme Court in Clinton easily concluded that when the president takes official action, the court has the authority to determine whether he has acted within the law. Reading of Youngstown, this court takes a quote from it saying, "No man in this country is so high that he is above the law. No officer of the law may set that law in defiance with impunity. All the officers of the government, from the highest to the lowest, are creatures of the law and are bound to obey it. It is the only supreme power in our system of government, and every man who by accepting office participates in its functions is only the more strongly bound to submit to that supremacy and to observe the limitations which it imposes upon the exercise of authority which it gives." The president does not enjoy absolute immunity from criminal subpoenas issued by state and federal prosecutors and may be compelled by the courts to respond. This court says we have 200 years of precedent establishing that presidents and their official communications are subject to judicial process even when the president is under investigation. Now, this paragraph that I'm going to read is important. The separation of powers doctrine, as expounded in Marbury and its progeny, necessarily permits the judiciary to oversee the federal criminal prosecution of a former president for his official acts, because the fact of the prosecution means that the former president has allegedly acted in defiance of Congress's laws. Although certain discretionary actions may be insulated from judicial review, the structure of the Constitution mandates that the president is amenable to the laws for his conduct and cannot, at his discretion, violate them. Here, former President Trump's actions allegedly violated generally applicable criminal laws, meaning those acts were not properly within the scope of his lawful discretion. Accordingly, Marbury and its progeny provide him no structural immunity from charges in the indictment. It's very important to note that he has under his discretionary power immunity, but when he is breaking the law, which is an express defiance of Congress's mandate, he has no immunity. So I'm going on. There are parts of it that explains it further, and I didn't want to be more verbose than I already am. The indictment, the Circuit Court concludes this part by saying, "We therefore conclude that Article 3 courts may hear the charges alleged in the indictment under the separation of powers doctrine, as explained in Marbury and its progeny, and applied in the analogous context of legislative and judicial immunity. The indictment charges that former President Trump violated criminal laws of general applicability. Acting against laws enacted by Congress, he exercised power that was at its lowest ebb. Former President Trump lacked any lawful discretionary authority to defy federal criminal law, and he is answerable in court for his conduct." So you have to see that, the presidential immunity bid doesn't extend to violation of criminal law. If Congress has set out a law that you cannot violate, and you go ahead and violate that and call it part of your official duties, it is by its very nature not your duty. Your duty as president is to take care of those laws, not break them. And this court goes very adamantly to explain that. So let me take another drink of water. Thank you for being here. If you're new to my channel, please like and subscribe. What I'm doing now is going through the appellate court decision saying that Donald Trump does not have immunity from criminal prosecution. I'm reading the the case and reading excerpts from it and explaining it to you. I've also provided the link to this appellate ruling in the description of this video. So please, if you want, read the ruling. Drink of water. Fear not, there's not much more left to this opinion. I am already more than halfway through it. So we go now to the policy considerations. Policy considerations is what is the public policy? What is the public interest? What is the general idea of the direction in which the body of law and jurisprudence should go? That's what policy means. You know, the penumbra, the surroundings of the implications of this particular ruling or the position that Donald Trump takes. You know, so that's what policy considerations mean. Excuse me. Even though it is proper under Marbury and its progeny for an Article 3 court to hear criminal charges brought against a former president, we necessarily must weigh concerns of public policy, especially as illuminated by our history and structure of our government, including our constitutional heritage and structure. This inquiry involves policies and principles that may be considered implicit in the nature of the president's office in a system structured to achieve effective government under a constitutionally mandated separation of powers. Our analysis entails balancing the constitutional weight of the interest to be served against the dangers of intrusion on the authority and functions of the executive branch. It's a broad ruling. It's, you know, and it's masterful. Court's not just talking about this particular case, but also about the executive branch and the broad principles of separation of powers that ties everything together. We note at the outset that our analysis is specific to the case before us, in which a former president has been indicted on federal criminal charges arising from his alleged conspiracy to overturn federal election results and unlawfully overstay his presidential term. We consider the policy concerns at issue in this case in two respects. First, we assess the possible intrusions on the authority and functions of the executive branch and the countervailing interests to be served as those concerns apply to former President Trump's claim that former presidents are categorically immune from federal prosecution. We conclude that the interest in criminal accountability held by both the public and the executive branch outweighs the potential risks of chilling presidential action and permitting vexatious litigation. So what we talked about before, right before I read this bit, you know, about the balancing of the interests of the Constitution and the dangers of intrusion to the executive branch. Second, we examine the additional interests raised by the nature of the charges in the indictment. The executive branch's interest in upholding presidential elections and vesting power in a new president under the Constitution, and the voters' interest in democratically selecting their president. We find these interests compel the conclusion that former President Trump is not immune from prosecution under the indictment. So the additional policy interest here is the interest of upholding presidential elections, vesting power in the new president, and the voters' interest in democratically selecting their president. Categorical immunity defense. So breaking down further. Former President Trump argues that criminal liability from for former presidents risks chilling presidential action while in office and opening the floodgates of meritless and harassing prosecution. These risks do not overcome the public interest in fair and accurate judicial proceedings, which is at its height in a criminal setting. So, going by the separation of powers and checks and balances, in a criminal setting, the judicial power of judicial proceedings is at its height, whereas a presidential immunity of a former POTUS who has been indicted for breaking the law is at its lowest. But the chance that we now and then, let me restart. But the chance that now and then there may be found some timid soul who will take counsel of his fears and give way to their repressive power is too remote and shadowy to shape the course of justice. The Supreme Court, reinforced the point in United States v. Nixon, holding that it could not conclude that presidential advisors will be moved to temper the candor of their remarks by the infrequent occasions of disclosure because of the possibility that such conversations will be called for in the context of criminal prosecution. We cannot presume that a president will be unduly cowed by the prospect of post-presidency criminal liability any more than a juror would be influenced by the prospect of post-deliberation criminal liability, or the executive aide would be quieted by the prospect of disclosure of communication in a criminal prosecution. Moreover, past presidents have understood themselves to be subject to impeachment and criminal liability, at least under certain circumstances, so the possibility of chilling executive action is already in effect. When even former President Trump concedes that criminal prosecution of a former president is expressly authorized by the impeachment judgment clause. So that's, when you go to the oral arguments where the court pretty much decimated Sorrow, Donald's attorney, where he could not get out of the impeachment judgment clause, the court got the concession it needed to explain to us that, they themselves are saying that they're not completely immune, and then they're asking for complete immunity. So I love that the court brings it up and the oral argument. It's just poetry. Additionally, recent historical evidence suggests that former presidents, including President Trump, have not believed themselves to be wholly immune from criminal liability for official acts under their presidency. So we talked about President Nixon and offering him a full pardon. Then there's, before leaving office, Bill Clinton agreed to 5-year suspension of his law license and $25,000 fine in exchange for independent counsel Robert Ray's agreement to not file criminal charges against him. I didn't know that. President Trump's 2021 impeachment proceedings for incitement of insurrection, his counsel argued that instead of post-presidency impeachment, the post-presidency impeachment, meaning, by the time the impeachment proceedings were happened, he was already a former president. The appropriate vehicle for investigation, prosecution, and punishment is the Article 3 courts, as we have a judicial process and an investigative process to which no former office holder is immune. So, this is Donald's impeachment haunting him, and his own counsel's arguments haunting him now. It doesn't help him. In light of the express mention of indictment in the impeachment judgment clause and recent historical evidence of former presidents acting on apparent understanding that they are subject to prosecution even in the absence of conviction by the Senate, the risk of criminal liability chilling presidential action appears to be low. Instead of inhibiting the president's lawful discretionary action, The prospect of federal criminal liability might serve as a structural benefit to deter possible abuses of power and criminal behavior. As District Court observed, every president will face difficult decisions. Whether to intentionally commit a federal crime should not be one of them. Former President Trump next urges that a lack of criminal immunity will subject future presidents to politically motivated prosecutions as soon as they leave office. In the civil context, the Supreme Court found official act presidential immunity necessary in part to avoid subjecting the president to trial on virtually every allegation that an action was unlawful or that taken for a forbidden purpose. But the decision to initiate a federal prosecution is committed to the prosecutorial discretion of the executive branch. Prosecutors have ethical obligations not to initiate unfounded prosecutions, and courts presume that they have properly discharged their official duties. These are, there are additional safeguards in place to prevent baseless indictments, including the right to be charged by a grand jury upon finding of probable cause. Grand juries are prohibited from engaging in arbitrary fishing expeditions and initiating investigations out of malice or an intent to harass. Additionally, former President Trump's predictive judgment of a torrent of politically motivated prosecution finds little support in either history or the relatively narrow compass of the issues raised in this particular case. President Trump acknowledges that this is the first time since the founding that a former president has been federally indicted. Weighing these factors, we conclude that the risk that former presidents will be unduly harassed by meritless federal criminal prosecutions appears slight. On the other side of the scale, we must consider the constitutional weight of the interest to be served by allowing the prosecution of a former president to proceed. The public has a fundamental interest in the enforcement of criminal laws. Our historic commitment to the rule of law is nowhere more profoundly manifest than in our view that the twofold aim of criminal justice is that guilt shall not escape or innocence suffer. As the Nixon court explained, wholly immunizing the president from criminal justice process would disturb the primary constitutional duty of the judicial branch to do justice in criminal prosecutions, to such an extent that it would undermine the separation of powers by plainly conflicting the function of the courts under Article 3. This is from US v. Nixon. There's also a profound Article 2 interest in enforcement of federal criminal laws. The president has a constitutionally mandated duty to take care that the laws be faithfully executed. The president is responsible for investigating and prosecuting criminal violations. Beyond simply making explicit that a president must enforce the law, the Take Care Clause plays a central role in signifying the principle that ours is a government of laws, not of men, and that we submit ourselves to rulers only if under rules. It would be a striking paradox if the president, who alone is vested with the constitutional duty to take care that the laws be faithfully executed, were the sole officer capable of defying those laws with impunity. The federal prosecution of a former president fits the case when judicial action is needed to serve the broad public interests in order to vindicate the public interest in an ongoing criminal prosecution. The risks of chilling presidential action or permitting meritless, harassing prosecutions are unlikely, unsupported by history, and too remote and shadowy to shape the course of justice. We therefore conclude that the functional policy considerations rooted in the structure of our government do not immunize former presidents from federal criminal prosecution. So it's categorical, as you can tell. And again, thank you for being here. We're at 40 minutes now. I'd say take another 20 minutes. If you're new to my channel, please like and subscribe. What we're doing now is going over the DC Circuit Court's ruling stating that Donald Trump does not have immunity from criminal prosecution. Let me take a drink of water and we will continue. By the way, if you have any questions, please feel free to leave them in the comment box or put them in the chats. And if you are here now, put them in the chat and I can answer them once I'm done with the reading. Back to the reading I go. Now, immunity from the indictment's charges. The allegations in the indictment implicate the Article 2 interest in vesting authority in a new president and the citizenry's interest in democratically selecting its president. The indictment alleges that the asserted official actions at issue here were undertaken by former president in furtherance of a conspiracy to unlawfully overstay his term as president and to displace his duly elected successor. That alleged conduct violated the constitutionally established design for determining the results of the presidential election, as well as the Electoral Count Act of 1887, neither of which establishes a role for the president in counting and certifying the Electoral College votes. The alleged conduct also violated Article 2's mandate that the president holding his office during the term of 4 years. The 12th Amendment reinforces the discrete nature of a presidential term, explicitly providing that the term of the president and the vice president shall end at noon on the 20th of January, and the terms of their successors shall then begin. Upon the expiration of that time for which he is elected, a former president returns to the mass of the people again, and the power of the executive branch vests in the newly elected president. And then there's the executive power shall be vested in a president of the United States. It's talking about one person here. The president, of course, also has the duty under the Take Care Clause to faithfully enforce the laws. This duty encompasses following the legal procedures of determining election results and ensuring that executive power vests in the new president at the constitutionally appointed time. To the extent former President Trump maintains that the post-2020 election litigation that his campaign and supporters unsuccessfully pursued implemented his take care duty, he is in error. Former president's alleged conduct conflicts with his constitutional mandate to enforce the laws governing the process of electing the new president. The public has a strong interest in the foundational principle that foundational principle of our government, that the will of the people, as expressed in the Electoral College vote, determines who will serve as president. The electors' vote shall meet in their respective states and vote by ballot for president and vice president. The person having the greatest number of votes for president shall be president. To justify and check the president's unique authority in our constitutional structure, Article 2 renders the president directly accountable to the people for regular elections. As James Madison put it, a dependence on the people is no doubt the primary control on the government. The, the Federalist number 51. Thus, the quadrennial, oh, I'm sorry, quadrennial presidential election is a crucial check on executive power because a president who adopts unpopular policies or violates the law can be voted out of office. Former President Trump's alleged efforts to remain in power despite losing the 2020 election were, if proven, an unprecedented assault on the structure of our government. He allegedly injected himself into a process in which the president has no role, the counting and certifying of electoral votes, thereby undermining constitutionally established procedures and the will of the Congress. To immunize the former president's actions would further aggrandize the presidential office, already so potent and so relatively immune from judicial review, at the expense of Congress. Here we have the separation of the checks and balances issue coming up. Executive power has the advantage of concentration in a single head, in whose choice the whole nation has a part in making him the focus of public hopes and expectations. In drama, magnitude, and finality, his decisions so far overshadow any others that almost alone he fills the public eye and ear. No other personality in public life can begin to compete with him in access to the public mind through modern methods of communication. By his prestige as the head of state and his influence upon public opinion, he exerts a leverage upon those who are supposed to check and balance his power, which often cancels their effectiveness. We cannot accept former President Trump's claims that a president has unbounded authority to commit crimes that would neutralize the former foundational check on executive power, the recognition and implementation of election results. Nor can we sanction his apparent contention that the executive has a carte blanche to violate the rights of individual citizens to vote and to have their votes count. At bottom, former President Trump's stance would collapse our system of separated powers by placing the president beyond the reach of all three branches. Presidential immunity against federal indictment would mean that, as to the president, the Congress cannot legislate, the executive could not prosecute, and the judiciary could not review. We cannot accept that the office of the presidency places its former occupants above the law for all time thereafter. Careful evaluations of these concerns leads us to conclude that there is no functional justification for immunizing former presidents from federal prosecution in general or immunizing former President Trump from the specific charges in the indictment. In so holding, we act not in derogation of the separation of powers, but to maintain their proper balance. So again, reminding the broad and specific nature. This is an all-encompassing opinion. The ruling addresses the narrow instance of this case, as well as the broad check on presidential power when it comes to minding the laws of Congress and minding what the courts say in what the law is. Now going to the impeachment judgment clause. The strongest evidence against former President Trump's claim of immunity is found in the words of the Constitution. The impeachment judgment clause provides that the judgment in cases of impeachment shall not extend further than to removal of office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to the law. That language limits the consequences of impeachment or removal and disqualification from office, but explicitly preserves the option of criminal prosecution of an impeached official according to law. Former President Trump agrees that the impeachment judgment clause contemplates and permits the prosecution of a former president on criminal charges, but he argues that only that such a former president first must be impeached by the House and then convicted by the Senate. In other words, he asserts that under the clause, former presidents enjoy immunity for any criminal acts, violations of Congress, committed while in office unless he's first impeached and convicted by Congress. Under this theory, he claims he's immune from prosecution because he was impeached and acquitted. If the clause requires an impeachment conviction first, he may not be prosecuted. But if it contains no such requirement, the clause presents no impediment to his prosecution. Former President Trump also implicitly concedes that there is no absolute bar from prosecuting assertedly official actions. And he agrees that if he had been convicted in the Senate in that impeachment trial, he would not be immune from prosecution from official acts at issue here. He thus concedes that a president can be prosecuted for broadly defined official acts, such as ones alleged in the indictment. Under some circumstances, that is following an impeachment conviction. The impeachment judgment clause is focused solely on those who are convicted by the Senate following impeachment by the House. The second part makes clear that the limited consequences of impeachment do not immunize convicted officers from criminal prosecution. The party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. In former President Trump's view, however, the word convicted in the second phrase implicitly bestows immunity on presidents who are not convicted based on a negative implication. He asserts that the impeachment judgment clause presupposes that a president is not criminally liable absent a conviction in the Senate. Other courts have rejected this tortured interpretation of the impeachment judgment clause, which previously has been advanced to support claims of judicial immunity. Former President Trump's interpretation runs counter to the text, structure, and purpose of the impeachment judgment clause. To begin, former president's reliance on a negative implication is an immediate red flag. The framers knew how to explicitly grant immunity, and they did so in many instances. So I'm now going to talk briefly about the speech or debate clause being one of the immunities provided explicitly by Congress. Yet, they chose not to include a similar provision granting immunity to the president. The text says nothing about non-convicted officials. Former President Trump's reading rests on a logical fallacy, stating that if the president is convicted, he can be prosecuted. Does not necessarily mean that if he is not convicted, he cannot be prosecuted. Impeachment judgment clause contains no words that limit criminal liability. And to the contrary, it uses nevertheless to ensure that liability will not be limited even after an official is impeached, convicted, and removed from office. The text of the impeachment judgment clause reflects its purpose to allocate responsibility between legislative and executive branches for holding impeached officers accountable for misconduct. So the court is saying that look at the purpose for which the impeachment judgment clause was written. It's a very textual reading. It's a very historical argument that this court makes. And I'm sure it takes into consideration the originalist, textualist, and ultra-conservative Supreme Court, which may get to review this case should they take the case. And they're making this argument by saying that the text and the purpose of it was not what Donald Trump is using it for. Going back, the framers chose to withhold such broad power from the Senate, specifying instead that Senate could impose only political, not ordinary criminal punishments. The framers wished to make clear that a president would still be liable to prosecution and punishment in the ordinary course of law. As the Office of Legal Counsel noted, that second part makes clear that the restriction on sanctions in the first part was not a prohibition on further punishments. Rather, those punishments would still be available, but simply not to the Senate. To counter the historical evidence that explains the purpose of the impeachment judgment clause, former President Trump turns to one sentence written by Alexander Hamilton in Federalist 69. The President of the United States would be liable to be impeached, tried, and upon conviction of treason, bribery, of other high crimes and misdemeanors, be removed from office, and would afterwards be liable to prosecution and punishment in the ordinary course of law. He focuses on the word afterwards and suggests that the president is not liable to prosecution and punishment until after he has been impeached and convicted. But we think the more significant word in Hamilton's statement is liable, which means subject to. Hamilton specifies that a president would be subject to impeachment, trial, conviction, and removal from office, and afterwards would be subject to prosecution and punishment without regard to the verdict in the impeachment proceeding. Moreover, in the very next sentence of the same essay, Hamilton stresses that the president must be unlike the King of Great Britain, who was sacred and inviolable. The Federalist 69, that's part of Federalist 69. It strains credulity that Hamilton would have endorsed a reading of the impeachment judgment clause that shields presidents from all criminal liability unless they first impeached and convicted by Congress. In drafting the impeachment judgment clause, to the extent that the framers contemplated whether impeachment would have a preclusive effect on future criminal charges, the available evidence suggests that their intent was to ensure that the subsequent prosecution would not be barred. Another founding fathers, Joseph Story, explained that the impeachment judgment clause removed doubt that a second trial for the same offense, could be had either after acquittal or a conviction in the court of impeachments. Story explained that without a criminal trial, the grossest official offenders might escape without any substantial punishment, even for crimes which would subject their fellow citizens to capital punishment. Finally, the practical consequences of former President Trump's interpretation demonstrate an implausibility. The impeachment judgment clause applies not just to presidents, but also to the vice president and all civil officers of the United States. Thus, his reading would prohibit the executive branch from prosecuting current and former civil officers for crimes committed while in office, unless Congress first impeached and convicted them. No court has previously imposed such an irrational impeachment first constraint on criminal prosecution of federal officials. Even if there is a textual basis for treating presidents differently from subordinate government officials, as former President Trump suggests, his proposed interpretation would leave a president free to commit all manners of crimes with impunity so long as he is not impeached and convicted. Trump's interpretation also would permit the commission of crimes not readily categorized as impeachable. Under the best reading of the impeachment judgment clause, a former president may be criminally prosecuted in federal court without any requirement that he first be impeached and convicted for the same conduct. So that ends the impeachment judgment clause argument. And, obviously, Donald's lawyers did not help when they argued this point in front of the court. To take another drink of water. Thank you for being here. If you are new to my channel, please like and subscribe. What I'm doing right now is going through the DC Circuit Court's ruling stating that Donald Trump does not have immunity from criminal prosecution. So stick around. We are almost towards the end. The double jeopardy issue is the last point. Double jeopardy principles. One thing to be made clear, Donald Trump doesn't talk about the double jeopardy clause, how as it applies. It's talk about the general double jeopardy principles that apply between impeachment and the judiciary. He's creating this, out of thin air. So here we go. Former President Trump, and one more thing, sorry. The fact that every time in this court points out and talks about Trump, it writes former President Trump, former President Trump, former President Trump. It is by design. It's the former president. And in the beginning, the court made that the power was vested in a president, and talks about the take care clause and how part of that take care clause is taking care that the process of succession happens as prescribed by law as well. So, here the court is separating, parsing through these, these specious arguments and these just frivolous claims, and sort of building the narrative, building the principles on which governmental immunity will stand. I believe that this will be an opinion that the Supreme Court would not want to touch, because this court covers pretty much everything on this one issue. It's a 57-page opinion on one single issue. Former President Trump alternatively argues that the impeachment judgment clause and principles of double jeopardy bar his prosecution because he was impeached by the House for the same or closely related conduct, but acquitted by the Senate. We disagree. The clause simply does not speak to such matters, but the weight of historical authority indicates that the framers intended for public officials to face ordinary criminal prosecution as well as impeachment. To the extent former President Trump relies on double jeopardy principles beyond the text of the impeachment judgment clause, those principles cut against him. Double jeopardy clause provides no person shall be subject for same offense to be twice put in jeopardy of life or limb. It has been interpreted to prohibit imposition of multiple criminal punishments for the same offense. Under precedent interpreting double jeopardy clause, former President Trump's impeachment acquittal does not bar him from subsequent criminal prosecution for two reasons. One, an impeachment does not result in criminal punishments. And two, the indictment does not charge the same offense as the single count in the impeachment resolution. So there's a design to all of this. The impeachment was for inciting an insurrection, but incitement of insurrection is not a charge uh, that Jack Smith has brought. And so the court here is breaking it down and saying that this is why the double jeopardy clause does not apply. First of all, because double jeopardy clause applies only to criminal instances and does not apply to the impeachment judgment clause. Uh, I'm going to read further how it explains the impeachment judgment clause here. Double jeopardy guards only against imposition of multiple criminal punishments for the same offense. Although double jeopardy applies only to criminal punishments, impeachment poses political punishments. Impeachment is a political process that is instigated and overseen by Congress. It is a tool entrusted to elected officials and designed to enable Congress to protect the nation against officers who have demonstrated that they are unfit to carry out important public responsibilities. The consequences imposed by an impeachment conviction, removal from office, and disqualification from future service, are intended to hold officials politically accountable while leaving criminal accountability to the judicial branch. As a result of the political nature of impeachment proceedings, impeachment acquittals are often unrelated to the factual innocence. In impeachment proceedings, there will always be the greatest danger that the decision will be regulated more by comparative strength of parties than by the real demonstrations of innocence or guilt. 43 senators who voted to acquit Donald Trump relied on a variety of concerns, many of which had nothing to do with whether he committed the charged offense. Indeed, at least 30 senators who voted to quit relied, at least in part, on a belief that Senate lacked the power to convict former president. Because at the second impeachment trial, again, Donald Trump was a former president. And that was the predicate that many of the senators took when they voted to quit. Criminal prosecutions, by contrast, are aimed at penalizing individuals for their criminal misdeeds by taking away their life, liberty, or property. The consequences of a criminal conviction are predicated on a finding of guilt beyond a reasonable doubt. And such consequences can be severe, including asset forfeiture, incarceration, and even death. Criminal prosecutions are overseen by the judiciary, which enforces stringent procedural protections that reflect the gravity of the potential ramifications for the defendant. The double jeopardy clause is one such procedural protection, ensuring that a criminal defendant is not forced to face prosecution twice for the same offense. In light of the very different procedures and purposes associated with impeachment proceedings as compared to criminal proceedings, former President Trump's reliance on the double jeopardy clause is misplaced. Impeachment is not a criminal process and cannot result in a criminal punishment. He does not seriously contend otherwise, and he does not explain why he believes that impeachment can implicate double jeopardy principles when it does not involve criminal punishment. And the reason why he can't is because he can't. It factually is not possible for him to say that because, he has not been criminally punished for it. Even if we assume that an impeachment trial is criminal under double jeopardy clause, the crimes alleged in the indictment differ from the offense for which President Trump was impeached. In determining whether two charges are the same, for double jeopardy purposes, the court applies the same elements test. If each offense contains an element not contained in the other, the offenses are different. An element is, if you're committing a crime, there are certain steps that go towards committing the crime. Breaking and entering, for example, would have breaking and entering a dwelling with the intention of committing burglary. So giving an example of breaking and entering, you'd have to break the door, you'd have to enter through that broken door. Then you have to have the intent of committing a crime when inside, to go beyond breaking and entering being the trespass offense. So for the trespass offense, the elements would be breaking the door and entering through. So same way, every crime has elements. So here it says, in determining whether two charges are the same for double jeopardy purposes, courts apply the same elements test. If each offense contains an element not contained in the other, the offenses are different. So if the charges at issue are not the same offense under the test, double jeopardy does not bar the prosecution. Under the Blockberger test, none of the four offenses alleged in the indictment is the same as the sole offense charged in the articles of impeachment, in the article of impeachment, the single article of impeachment. The indicted criminal counts under conspiracy to defraud the United States, conspiracy to obstruct, then obstructing, and also deprivation of rights. By contrast, the article of impeachment charged President Trump with incitement of insurrection. So they are not the same offenses. Each of the indicted charges requires proof of an element other than those required for incitement. So here the court is breaking down why, even if you were to consider the impeachment to be a criminal trial, even then the elements of the crimes are not the same. He's been charged with different crimes than for which he was impeached. In other words, the charges are not the same under a straightforward application of the Blockberger test. Former President Trump does not dispute this analysis and instead contends that rather than applying the Blockberger test, a subsequent criminal prosecution cannot be based on the same or closely related conduct. So now Donald Trump's argument is that if two crimes are committed on the same and are based on the same conduct, such as, I'll give you an example, attempting to, conspiring to obstruct and then obstructing. So they are two different crimes, but the same conduct. There has to be a specific intention element in a conspiracy in the meeting of the minds that is not present at the actual obstruction statute, because the actual obstruction is the actions that have been taken that cause obstruction. It's readily provable. The conspiracy charge has to be proven through the meeting of the minds and taking an overt step. So that explains to you the difference between the elements and the conduct test. So the same conduct rule is wholly inconsistent. So here the court says that doesn't work under the Supreme Court precedent. The same conduct rule is wholly inconsistent with Supreme Court precedent and with the clear common law understanding of double jeopardy. The double jeopardy clause is not implicated simply because a criminal charge involves essentially the same conduct for which a defendant has been previously punished. Perhaps recognizing that normal double jeopardy rules disfavor his position, he claims that the impeachment judgment clause incorporates double jeopardy principles that are distinct from the double jeopardy clause. But if the double jeopardy principles he invokes, if the double jeopardy principles he invokes are unmoored from the double jeopardy clause, we are unable to discern what the principles are or how to apply them. He thus fails to establish that his Senate acquittal bars him from criminal prosecution. So lastly, the last conclusion of the court goes as such. We have balanced former President Trump's asserted interest in executive immunity against vital public interests that favor allowing this prosecution to proceed. we conclude that concerns of public policy, especially as illuminated by our history and the structure of our government, compel the rejection of his claim of immunity in this case. We also have considered his contention that he is entitled to categorical immunity from criminal liability for any assertedly official actions that he took as president, a contention that is unsupported by precedent, history, or the text and structure of the Constitution. Finally, we are unpersuaded by his argument that this prosecution is barred by double jeopardy principles. Accordingly, the order of the district court is affirmed. So that is the ruling. And thank you very much for being here. Sorry it's gone for so long. Just briefly, thank you, Derek, for being here. Just briefly, going to say that this is a broad opinion and a specific opinion. It is a textualist's dream and an originalist's dream, and it really, just parses through the various arguments and the various reasons for which there's no immunity from criminal prosecution for former presidents. And the arguments made are strong enough that Donald Trump would think twice before appealing. And I would think that the Supreme Court is unlikely to take this appeal. They may just let this ruling stand because this is an interlocutory ruling. And this is, after this ruling, now the district court's case can move forward now. The pretrial processes can move forward. So the Supreme Court has to take that into consideration as well. For one issue, the court spent 57 pages and explained categorically and broke down even the most farcical arguments that Donald Trump had. And I believe that, justice would be better served if the Supreme Court didn't take this ruling. And even if they do take the review for this case, I hope that they don't stay the trial procedure as they're reviewing, but they might if they take the ruling. So with that said, thank you very much. When more documents come out and more issues come up, I will discuss. And thank you so much for giving me your time. Take care. Talk to you soon.